Good morning, and thank you for registering and attending to FinPro's webinar on corporate governance. Today's presenter will be Don Musso. We are waiting for a few more people. We know that we've got a little over 100 now. We anticipate that we'll have approximately twice as many by the time we start in a minute or two. We will be starting in 1 minute. Just wanted to verify for everybody on the phone that you should see our screen now, and that Don Musso will be presenting on today's corporate governance webinar presented by FinPro.
You guys there?
Hi, Don. Yes.
All right. So you can do the lead-in whenever, and we'll get going.
Sounds good. For everybody on the phone, thank you for attending today's FinPro Corporate Governance webinar. You just heard Don Musso, President and CEO of FinPro. He will be presenting today from California. We're here in New Jersey. I just want to note that just in case we have any technical difficulties, we do have corporate governance experts here on hand. But speaking of experts, I'll introduce Don in a second. I just want to talk about a couple administrative items today. Questions are encouraged on the right-hand box of your question box if you want to type a question. If you feel that it'd be better to converse or you would like to have a discussion with Don or engage them on any question, just type the fact that you would like us to unmute you, and we will unmute your phone, and then you can have that conversation with Don. For those seeking CPE credits today on the phone, either in New Jersey or any state that has reciprocity with New Jersey, please type the code CGMT 2017 and then your name in the question box. This will verify your active participation. We'll do this again at the end of the webinar. Today's webinar should run roughly 1 hour. The topic is corporate governance. This is the second this year of FinPro's webinar packages. It is not too late to sign up for the 2017 webinar package. All recordings are available through the subscription, and it includes unlimited registration for unlimited people at your institution to all 26 webinars in 2017. Our next webinar is stress testing. This is a particularly hot one. I think we're going to set a record with attendance already for registrations. If you're not registered, I encourage you to do that. That falls on February 2nd. At this point, I'd like to turn over to Don Musso, President and CEO of FinPro. Don is an expert on the corporate governance topic, and not only in theory, but also in practical wisdom. He has served on many boards of banks, is a major investor, and has been for the better part of the 30 years that FinPro has been in existence, and even before then. And like I just alluded to, FinPro, the company that he has founded, a consulting firm, has been in existence for over 30 years, serving the banking industry. Don, take it away.
Thank you very much, Steve. Welcome, everybody, from sunny California. It's actually as warm in New Jersey as it is here in California today. But I'll be here for a couple of days, and I'll be back to lovely New Jersey. All right, today we're going to talk about corporate governance. I'll get through it relatively quickly. But I'd like to start by talking about change again. And this is a slide that is usually the concluding slide for my speech that I give on change and the speech that I give on where banking is going in 2020. So I thought it would be smart to start with it again. You know, I think we all know that we have changing demographics, particularly that millennials now outnumber baby boomers. What's not talked about in demographics enough, though, is that as baby boomers now go into retirement, they're going to start drawing down their 401ks, and they're going to start drawing on their pension plans. So we're about to see a pretty big movement of money out of funds and back into individual hands. We all know about changing technology and fintech. I've spent a lot of time talking about that. We got to stop the OCC from giving fintech charters, but most importantly, we got to stop the FDIC from giving deposit insurance to fintech organizations. It is our competitive advantage. According to Donald Trump this week, he's going to eliminate 75% of all regulation, which would dramatically reduce the compliance burden. Here's hoping, but I'm not sure that here's believing yet. I'd be happy with a 25 to 30% reduction. So let's cheer him on. We are definitely going to see changes in the CFPB. I believe you're going to see Cordray reporting to the Federal Reserve Board, and his budget will be appropriated by Congress. I also think that he'll be asked to resign early. Whether or not he battles back remains to be seen. It's going to be an interesting, fun time there. The other thing on the regulatory side is that in another 45 days or so, Tom Curry's term expires at the OCC, and he will be replaced. And in November, Marty Grunberg at the FDIC, his term is up. And we have 2 open Federal Reserve seats. It's going to be interesting to see how that plays out. We have a separate series of special webinars going on relative to the economy. Is the Trump bump sustainable, or is it the prelude to a fall? Steve, at the end of this webinar, will tell you when the next one is. We encourage you to participate in that. But the economy certainly is still not on rock-solid ground. We've already talked about regulated competition, and I think the last bullet here is undereducated and undertrained staff. I think the differential for banks that are going to win and banks that are going to lose in the next 5 to 6 years is going to be he or she who has the best people is going to win the race. So that brings us to hiring, training, retaining our people, and the like. So to create value, we've got to change our delivery channel from being just brick and mortar to being human, digital, and brick and mortar. We've got to take the focus off of transactions and move it to relationships, which means we're going to focus on customers, not on products. And that means we've got to change our organizational structures accordingly. All of that falls under corporate governance. We've talked about talent management. That falls under corporate governance. One of the board's primary responsibilities is to attract and retain key people. And then, how we brand ourselves in a highly commoditized world. And I'm not going to spend much time on that one today. Finally, what it means is we've got to get to the single engine. Many of you on the phone, we work with you, and we are using a single engine now. So I think the analytics between asset liability and budgeting and planning and enterprise risk and stress testing is all embedded in one single engine right now, which is the way to do it. Now we're shifting emphasis to stressing individual variables in stress tests and scenarios, all the way up to DFAST testing. Corporate governance, I'll show you, is a hot regulatory button right now. So is board training. We're moving our clients towards customer segmentation and more talent management. Net, all this is coming about because the regulators are worried about change. They're worried about strategic risk. So when you look at this chart in particular, I'll bring the whole chart up here. Corporate governance really is the framework under which a board and senior members of the management team can manage the organization. So, it's their responsibility at the top of the house to set strategy and to set objectives, not to do detailed tactics. That's management's job. But the board's job is to set strategy. And, of course, management's got to be actively involved in that. The board's got to establish the risk governance framework, and they've got to set risk tolerances. Management can recommend, but management can't recommend and approve. The board can approve. It's their job. Therefore, we've got to be able to identify, measure, monitor, and control risks. That is the entire shooting match from a regulatory perspective today. And we've got to be able to supervise the bank's business. That means we've got to get good reporting, and we've got to talk about board meetings and board packages and the like. And then we've got to remember that we're not just there to serve customers. We are also there to serve shareholders. We're there not just to serve shareholders, but we're also there to serve customers and employees, and we have a regulatory stakeholder as well. All this means we've at some point have to align the culture to get us where we need to be. As we look at our 400 plus some odd clients across the country and our dozen or so international clients right now, we're finding that most of the bank problems that we're asked to fix from a regulatory perspective are the result of a misalignment between management and the board in some way, shape, or form, primarily relative to the dot points that you see on this page. It's even more troubling that the FDIC continues to go after board members of failed institutions. Now, I certainly understand it in the first dot point where it's dishonest conduct or abusive insider trading. Unless the dishonest, I'm involved in an expert witness case right now, one of the largest in the country, where there was a fraud perpetrated by some outside mortgage bankers, some inside mortgage bankers, and it was perpetrated not just on the board, it was perpetrated on the accounting firm, the internal audit firm, it was perpetrated on senior management. So, everybody's going to remember that audits are not designed, they're not going to find fraud because they don't look at every single transaction, they take a representation. So fraud's going to continue to happen, and we've got to understand that we've got to do everything we can. We need to be state-of-the-art to make sure that we're managing fraud. Second reason, failures for banks to adhere to law, internal policies or supervisory agreements. That primarily we're seeing in the form of BSA, CRA, AML, those kinds of things. And we're seeing an abundance of unfair deceptive acts, UDAP kind of things right now. So that means we need to understand those rules, we need to have people monitoring it, and we need to get reporting to the board that says we're in compliance. Then the third one is failure to establish proper underwriting policies. Almost every memorandum of understanding that's been issued, almost every consent order that's been issued has a codicil in it that says, you need to significantly enhance your policies and procedures, and credit's almost always one of them. We're also seeing interest rate risk in a number of cases. We're also seeing a number of them coming up right now in terms of just overall regulatory compliance and guidance. On this page, I'm showing you the two releases from the spring of last year by two of the three largest federal agencies for banks. The left one by the OCC, the right one by the FDIC, both of them looking at corporate governance, zeroing in on corporate governance as a risk to banks. The one from the OCC really starts to align corporate governance with strategic risk and talks about how if you want to manage strategic risk, you've got to have the right corporate structure in place, you've got to have the right corporate governance processes and procedures. So the OCC is, and Tom Curry has made no bones about it. To him, strategic risk is the number one risk banks face, and really that's a business model issue, which we'll talk about in the next slide. They use as evidence that we're 7 years into a bull market, and that as we get into the tail end of a bull market, banks tend to start accumulating risk by decreasing their underwriting standards or taking on more interest rate risk and the like. They also talk a lot about how technology could significantly enhance strategic risk for banks if we don't keep par. And it talks about that banks are, to keep par, banks are trying to get more and more innovative in the products and services that they're offering, but they aren't vetting them appropriately. I'm not sure that I'm 100% in agreement on all these issues, but I will tell you that I think the premise is correct on strategic risk. The next page really gets into the detail. The first is the adequacy of business models. Second is board and management succession. And the third is depth of staff expertise. I don't know that they needed any more dot points. To me, if you want to understand strategic risk, here it is. Strategic risk includes adequacy of your business model, board and management succession, and the depth of your staff. I mean, to the extent you've got all those things allow you to go out and find market opportunities that you can take advantage of. We are seeing incredible competition in lending. I, however, am not seeing at our 400 clients relaxed credit standards. So I'm hearing anecdotally about it in the marketplace. At a meeting Scott Polikoff and I recently had with the FDIC, they specifically brought it up. We asked them to give us some examples because we don't have any of them in our clients. But they are very, very worried about it. I think it's more worry than actuality right now. Although in some markets like New York, we are seeing crazy low market cap rates. When we talk about assuming a new risk or an unfamiliar risk, really what the regulators want us to do is say, do we have the right people, systems, and controls in place to manage that risk, i.e., do we understand the business that we're getting into? They don't want us relying on third-party vendors exclusively for those things. They want us to take control of it. And if we are going to rely on third parties, they want us to manage that. and they want us to make sure that we understand the IT that goes along with it. And that's, you're going to see in 2017, that's going to be one of their biggest bugaboos. And then, of course, there's the traditional reaching for yield that they always talk about. The FDIC
Sorry, Don, we have our first question. I think now might be a good time to address it, or you can table it if you want, and you're going to get to it.
No, go ahead.
I'll paraphrase. The question says, how and when should the board be reviewing loans, if they should at all?
Yeah, this is an ongoing it's an ongoing battle that we're having with a number of banks across the country right now. And I'm not sure there's a right or wrong answer to it. I would tell you that right now, more banks than not are still have board members looking at loans, but the veracity of the curve is leading towards board members in particular not being involved in loan committees anymore. And it's really a risk-driven thing. My personal position on it, which I've expressed a number of times, is that board members' responsibility is to set policy. And within policy, management should be able to run freely as long as their work is being checked by internal audit, external audit, and compliance folks. But any exceptions to policy, or certainly any exceptions to any rule or law, absolutely positively has to come to the board. And I would include in that, of course, all the Reg O loans and all that stuff. So it's a great question, not a great answer yet because the market is still somewhat split. There really isn't any regulatory pronouncement one way or the other on that topic. So, I would say take a look at your own situation and spend more time getting the policies right. Because I will tell you that if your board's approving a lot of exceptions and those loans go bad, you have a lot of culpability there. The board members have a lot of culpability. So you should see less and less and less exceptions that are going on with loan committees, and that means everybody's got to redo their policies. Shoot, the bank that I'm on the board of, we've redone our loan policy 3 times in the last year, and I think we'll probably do it 3 more times in 2017 to get it right. So you just can't stay on status quo. Let's just talk about the FDIC really quick, and I want to cover just a couple highlights here. The first is that the FDIC basically says the same thing that the OCC does. It places significant emphasis on the 4th dot down, credible challenge. And credible challenge basically is, do your minutes demonstrate that the board of directors is asking enough detailed questions and probing? Are they voting even though they don't have all the information, or are they pushing the vote off and delaying it until they get the adequate information that they need to be able to make an appropriate decision and take a vote? Therefore, credible challenge has to be demonstrated in writing in board minutes. And I was at a conference last week where an attorney stood up and said, well, we think shorter minutes are better than longer. And I said, well, I can't disagree with you more, and you clearly haven't been in the regulatory world for the last 500 years, because the regulators are killing people on an inadequate documentation. And it's not a credible challenge. Could be as simple as somebody just asking. It doesn't mean you have to have people voting no on things across the board. It's just that they're asking detailed questions, probative questions, making sure that the information that we need to make a decision is there, or emphasizing a point. I routinely in board meetings will say, I'm voting for this because I see this as being a real and I'll spell out whatever this is. And then the last dot point is something new. It's really a FinPro term called presumptive knowledge. But across the country right now, we are seeing the regulators expect that board members and senior officers have what we're calling presumptive knowledge, i.e. that they have an understanding of the rules and regulations that govern the entity. And if we don't, we're getting hammered for those things. So please pay attention to a credible challenge, document it in your minutes, and presumptive knowledge. You've got to also now be documenting the training that you're getting. This is a great example. You should take the output from this and attach it to your board minutes and say, look, we got trained in corporate governance. The more you document, the better off that you're going to be. The last issue is one called heightened expectations. And it really is that, in a nutshell, that the bar on corporate governance is being raised for everybody. Take strategic planning. In a strategic plan, it no longer is a flat rate single scenario. It now is multiple rate scenarios, multiple scenarios relative to what we can do in terms of lending volume and deposit volume. And so if you're doing a strategic plan today and you don't have at least a dozen paths, you're not meeting heightened expectations. You're not doing what all the other competitors are doing, and you're going to get written up for it. It's just a matter of when. You need to be doing a board assessment. This is hard stuff to do. It's really hard to look another board member in the eye and say, you need to become emeritus. You're just not active. You're not contributing. I don't believe this is an age thing. I don't believe in mandatory retirement age. To me, mandatory retirement is when people can't put the time in that's required, or when they can no longer mentally function. But in the board assessment, every board member has got to be active. They've got to be involved. They can't have dominant board members. All those kinds of things the regulators are looking at in excess right now. They absolutely are looking at director training, so much so that the FDIC, as you know, created its own series on director training and holds its own conferences on director training. So make sure that you're not only doing it, but that you're documenting that you're doing it. Internal risk assessments, particularly under Basel III, this is now an expectation, a heightened expectation that we're going to do our own risk assessment. And based on our risk assessment, it will tell us how much capital we need to hold. It will also tell us what kind of expertise we need to go out and hire. It'll also get into the dirt a little bit in terms of loan loss allowance and the like. And then lastly, the regulators want boards to understand that they have liability and what that liability entails. So let's talk about liability just for a minute. Everybody that we do work for, the boards and senior officers, think they're covered by D&O, E&O insurance, and by indemnification. As we've studied this, we found that, and as I've been involved in expert witness, I'm seeing firsthand that these are not the coverages we think they are. First and foremost, federal law limits indemnification that banks can pay to board members and officers if actions are brought by banking regulators. So you need to take a look at that. You may not, if you have a violation of reg or law, you may not be covered. Banks can indemnify individuals to pay for civil money penalties. And civil money penalties, at least in the last administration, were getting exorbitant. So, beware of that. And lastly, indemnification for legal costs and shareholder suits, they're generally permissible, but sometimes the carrier excludes them. What I'm encouraging people to do is go out, have your internal counsel, take a hard look at what your coverages are, make sure that you're protected, and make sure that the folks who are on the board table understand risks that they're taking. Because I think sometimes actions are taken without any regard to the risks that come with it. So I'm quickly going to go through several ways to mitigate liability, from robust corporate documentation down to effective use of time. First, I'll talk about documentation. Everywhere we go, we see documents that are just out of control. There's a proliferation of it, and nobody knows which is the appropriate, correct document. We don't have version control. We have examples of where we have a client right now in the Southeast who is looking at changing their employment agreements, and they couldn't figure out which employment agreement. They had 3 of them for the same person, couldn't figure out which one was in effect. It's crazy, and to me, this is so basic, and it's so easy to do. But a document repository is a necessary thing. We've got to control documents. With that, you've got to have detailed security. So permissioning who can see what documents is mission critical. And the document control is also important because things are falling through the cracks. Simple negligence. We have an example recently of somebody missing a lease, a notice period. They didn't know that they knew their lease expired in June of 2017, but they didn't know that they had a 120-day notice window. They thought it was 90, but it was 120. Well, they missed their notice window. Now all kinds of heck happens. So we encourage everybody in the system. We're building Bates stamps, critical final documents, and then there's only one document, and it's stored in one place. And we give people access to it, and we control access, and we know who looked at what document and how long they looked at what document. Robust corporate document control is mission critical. As I said earlier, get your outside general counsel or your inside general counsel to review your indemnification provisions and to review your D&O and E&O insurance policies. People ask me, well, why can't we just have our insurance agent do that? And I said, well, you certainly can, but I'm not sure that insurance agents are going to be completely objective and independent looking at policies that they're providing. Whereas counsel, who has nothing to do, they don't get paid for issuing insurance, I think will be mission critical, and will also be able to tell you whether or not any of the provisions that you have in your insurances and in your indemnification are any different than any other clients that you're dealing with. And we are finding that insurance policies are having more and more and more exclusions, so please get them looked at. You need to have a system in place. Many of you now have board portals. You all know how I feel about some board portals because I go to all these board meetings all the time, and people are bringing up their iPads and they're flipping through it. And nobody knows what page we're on, and nobody can find what we're doing. And so I'm more and more becoming a fan of the board portals that are controlled by the chairperson. And what the chairperson sees on screen, everybody sees on screen. So I can't have people out reading a magazine while the board meeting's going on, or checking out their emails, which is what routinely happens while we're in the middle of board meetings. As I said earlier, minutes need to reflect what actually happened. They need to be detailed, and they need to reflect credible challenge, but they also need to be timely. One of the big things that we've noticed recently is that, particularly in the expert suits that I'm involved in, to the extent you have board members who are taking notes, miscellaneous notes, on either hard copy or on a screen, those are discoverable. And I have one case that I'm an expert on now in the Colorado region that I have a feeling we might lose. And we're going to lose it because one director happened to write some things on the margin that should not have been written. And in that margin, this particular director questioned certain things that were being done, which basically play right into the hand of the plaintiffs. So be very, very careful about what you allow, who's allowed to write what on your documents, how you're going to keep your documents, and what's discoverable. Obviously, I don't need to spend too much time on this. Third-party related transactions have to be documented thoroughly. Spell out the conflict, then abstain or leave the room for all discussion. We're involved in another case right now where the minutes of the board meeting basically said they were voting on a Reg O loan that went bad. And when they were asking about some of the credit deficiency, if you will, in this Reg O loan, they were asking the individual who was getting the loan. So he was sitting in the meeting answering questions on his loan. Yeah, he didn't vote, but he was there influencing the outcome of a decision relative to, in this case it was a he, to his loan. Please don't do those kinds of things. Nothing will get you in trouble quicker than a related party transaction issue. I think most of you on the phone know that we have what's called the Regulatory Feedback Initiative. This chart that you see with the bubbles that are moving is a reflection of the way the regulators see risk and the way they saw it 6 quarters ago and then the way they saw it at December 31st, 2016. Every quarter, we get a series of questionnaires back from banks that have been examined on a no-name basis, and based on those, we give a report, an analytical report, to the state associations and to the FDIC and the OCC and the Fed Reserve, and it lays out what we're seeing happening in risk, where regulators are being consistent, where they're being inconsistent, and why. So that, if you're getting these questionnaires, please take the time to fill them in. They're confidential. Nobody knows who the bank is that's filling in the data, but this data is absolutely being utilized, and it's helping the industry greatly. I can't tell you how many policy meetings I've been in the last year where this chart has come up and we have gone off on a bubble and had robust debate about whether that bubble should be moving right or left. And I will tell you, Scott and I have a meeting in early March down with all the FDIC policymakers to do just this again. And we're going to talk about how we expect to see this risk matrix move if the Trump bump continues versus what happens if the Trump bump is popped, the bubble's popped. We talked about ongoing training for directors. I don't think I need to spend too much time on this, but remember, this is the vehicle that beats presumptive knowledge. So presumptive knowledge is they assume that you understand certain matters. Make sure you've done the training. If you've done the training and participated in the training, you have significantly likened the chance that you meet the prudent businessman rule. You know, that you were educated and that you were making informed decisions. It's hard to make a decision on a topic that you don't know anything about. Then we have effective use of board time. I'll spend a little bit of time on this. A great example, I got into California last night. I probably landed at like 7:30. Got to the hotel 8:40-ish and was able to, for 2 hours, look at all of the legal documents for our company because they're all online in CGMT. And I was able to mark up a significant amount of documents and move them back and get them done. And it's all done securely. I'm not having to do it using an insecure email or text kind of a platform. So, you know, good board, effective use of board time starts with us having good data and access to the data beforehand so that we've had time to review it. And then it's what do we do, you know, in terms of managing the board meetings, and I'll talk about that in a second. Not going to spend time on this because it's boring as hell, but every board member has the duty of loyalty and the duty of care. Duty of loyalty means you act honestly and ethically. Duty of care means you beat presumptive knowledge, that you get educated, that you get trained, and that you know, you're making sure that you're not voting unless you have the information to vote. In making decisions, I think directors generally are held to a standard that says, were their decisions made on an informed basis? Were they made in good faith? And were they in the best interests of the corporation? So, you know, everybody kind of gets into the legal mumbo-jumbo. I think if you just use this one dot, every time you're about to vote, ask yourself, have I been informed? Am I making an informed decision here? Am I making it in good faith? And, you know, is this what's best for the company, or is this what's best for Don Musso, or what's best for President A, or for board member B, right? If you do these things, I think you'll be fine. And then this page, which you'll get, walks through the three of them again. I want to spend a few seconds on this standard for breach. Historically, it's been gross negligence. The FDIC lawsuits against failed bank directors is trying to shift the standard to simple negligence. I have simple negligence every day. So does every single person on this phone. So to the extent that the FDIC magically wins, and they won't, but if they did, we would be the only industry in the United States that would be held to the standard of simple negligence, which is an impossible standard to meet, which means I would immediately resign my board seat because it's a risk that's way too big for any person to take on. Gross negligence basically says that you did something willingly or with intent. And, you know, I think when you do something willingly and with intent, you should get in trouble and you should be prosecuted. So I think this is one with, you know, Judge Boyle in North Carolina 2 years ago slapped the FDIC big time on this issue. I thought it was over 2 years ago, but the FDIC keep bringing these dead burn lawsuits. It's driving me crazy. And then I already talked about credible challenge and presumptive knowledge. Okay, let's talk about conflict transactions. I'm seeing a lot of transactions again where board members are buying property and building buildings and leasing them to the bank. And the problem is that a majority of the board members are involved. And so the question then becomes, well, what do we do? Well, now you go to the standard of comparability. On anything that you think there's a conflict, always shop it, always get something that's a set of comparables that you can use to say what we're doing is fair and what we're doing is not taking advantage of the bank. Otherwise, we're back to, you know, we didn't act in good faith. We acted in our best interest. So when will you kind of be deemed to breach your duty? Well, we're back to the fairness issue. And if you haven't made it your decisions fairly, this is liability that you cannot get covered in D&O, you cannot get covered in E&O, and you will not get indemnified. So I tell everybody all the time, particularly new directors, when we do new director training, the number one thing that you have is your integrity. Don't give that away to anybody for any reason ever. By the way, this is now moving into compensation-related issues as well, particularly board members when they vote on their own pay. We have some dissidents who are out saying that that's an absolute conflict of interest. I mean, purely on paper, they might be right, but that's all the more reason to have an independent comp committee and to have compensation analytics being done. Even if you're not a public entity, that's probably a good standard to hold yourself to. It's just getting so much scrutiny right now. Why open yourself up for issues that you don't need? Bank directors, though, absolutely cannot be involved in day-to-day operations. They've got to get out of the weeds. They've got to get out of the day-to-day management. Now, I will tell you that in a meeting that we had with the OCC, I want to say October last year, we spent a lot of time on this very topic, and we said to the OCC, we don't want board members to be in the weeds. We don't want them to micromanage. But you guys keep forcing it, you guys being the regulars, by asking for more and more and more and putting more and more onus on directors to know things and do things. There's got to be some semblance of balance here. I'm hoping that we, under the new regimes, when Grunberg leaves and Curry leaves, I'm hoping that we're going to see some form of return to balance here. But just be aware that the regulators are kind of forcing micromanagement in some ways right now, and boards are having a difficult time figuring out what they have to do to meet their fiduciary duty and where they need to stop to avoid micromanaging. This one's near and dear to my heart. I think strong corporate culture starts at the top of the house, and it carries its way through an organization. So I actually put up here our corporate culture at FinPro. I thought it'd be helpful for you to be able to see this. And what it basically says is we have 10 things that are absolute truths in our company. First is that you put FinPro first. That's not above family, but that means you put FinPro above your division or yourself. Take responsibility and then accept accountability that goes with it. I think we're sorely lacking that across the entire United States right now. No excuses, just do it. Everybody can come up with 1,000,001 reasons to have something take an extra, day or week or month. But there gets a point in time where we just need to get stuff done. Communication, I think everybody would agree with that. Intellectual curiosity is one that I don't see enough of in our industry. I think people get pigeonholed in an area, and they know their area really well, but it doesn't seem to me that they're trying to learn all of the facets of banking, and that they want to understand, how retail banking works, how commercial banking works, how back office works, what technology is doing, and the like. In our case, I think now in your case, and I think the OCC proves it with the document they issued, you got to innovate. And that means we got to embrace change. We can't fight it. If we fight it, we're going to lose. We're going to be out of business. The last three are really more, I call them airy-fairy. They're softer issues. But from our perspective anyway, we're small enough that we're still an extended family, and we need people to trust, in the people in the foxhole next to them. We're all in it together. When one person goes, has an issue, the rest of us have to pick up and carry the day. If it's in your heart, it's right. Most people, tend not to follow their gut instinct and what their heart's telling them is the right answer. And then we got to have passion. So I think culture is a reflection of your organization. I do not, at the vast majority of the banks that we work for, I do not see culture. People say, well, what is our culture? And I say, I don't have a clue. What do you think it is? And then if I ask 3 people in a group, I get groupthink. When I separate them and I ask them, I get 3 completely radically different answers. When you're doing and building culture, you want to start individualistically doing it so that there's no repercussions. Then you want to bring it all together and try to get cohesion. Ethics. I'm not going to spend more time on this. I think everybody gets this one, fairly straightforward. But I think the ethics, these are the 12 areas that boards are judged on by the regulatory agencies. I do want to spend a few minutes on meetings.
Hey,
board
Don?
Meetings. Yes, sir.
Don, we have another question. We've had a couple. We're going to follow up with people in the interest of time if we don't get to all of your questions. But when you're touching on meetings, we had a question specifically on discussing more about PDF documents and the frustration of PDF documents in meetings. I think that ties nicely with this slide, so I just wanted to make you aware of that question.
Okay, and I will address that. Let me hit the broad genesis first, and then I'll get into that specific piece of it. Board meetings are proliferating right now, and they're proliferating because we've got to know so much, and we've got to be trained so much, and there's so much information, and. So board meetings that used to go an hour or two are now routinely going 3 to 4 hours and then some, and there's homework that has to be done before the meeting, and there's usually telephonic meetings in between, and then there's committee meetings, and being a board member is much more challenging than it's ever been. But we can do things that make life easy. Simple things like scheduling meetings a year in advance, always having an agenda and following the agenda, and having the agenda do the heavy lifting for you. This is an action item that we need to vote on. This is information only. This is for discussion. Information only, if we get to it, we get to it. Action item, we're going to vote on it before we leave the meeting. Discussion, we need to talk about this and figure out what our next steps are. We obviously got to get the information out timely. That's pretty hard to do. But, you know, again, we're finding that people are trying to send out whole board packages, and this ties into Steve, the comment on PDFs. Because board portals are making you use PDFs, you've got to get the whole PDF put together and page number before you can send it out to the board. The board portal that we've built and are using around doesn't do that. Ours is we can get a document, post it, and therefore we can build the agenda. If we had a board meeting yesterday, we can start building the next one today and start posting documents on a timely basis as they come out. PDFs are also very cumbersome to use. Most of the board portals today don't allow you to use Excel. They don't allow you to have PowerPoint with animation, all kinds of stuff. It's just fundamentally the wrong way to hold board meetings. So make sure you get your information done, get it out in advance, but also find ways to get it out so that you're not hitting people with a 5,000-page document, even if it's a week before. How many of you have gotten a 5,000 page document and read the damn thing? Not many. You need to make sure that you're getting management expertise in the areas when you require it. But even there, we don't have CFOs report financials every month anymore. Boards are trained and they know how to read them, but they do them every quarter. And we're doing the same thing on lending. If we don't have any exceptions, lending can be all done in a consent agenda. And so the use of consent agendas is also becoming more and more prevalent. Will also save you more and more time. If you're going to use consent agendas, you've got to start by saying, did everybody get the information? Did you have a chance to read it? And are there any reasons to pull this out of consent agenda, i.e., are there things that people want to talk about? So ask those 3 questions. As I said, minutes have to be more detailed. They got to reflect different points of view, and the like. This is an area where I think corporate governance is falling woefully short. When I attend board meetings, most of the time is spent on things that have already happened, not on what is going to happen and what we can do to change that course. Good example, right now, who gives a damn what happened at 12/31? We can't do anything about it. But I very much care about what we can do to make and change the numbers through March and through June of 2017. So, I want to understand where the economy is going. I want to understand where loan volume is going. I want to understand all that stuff. I want to understand some of the things that have happened in the past. So, I want to get a report that will tell me these are all the SARs that were filed, for example, and, kind of here's the topics around those. But more importantly, what I want my compliance officer to do is tell us, and based on that information, we're changing our processes the following way to mitigate that risk on a go-forward basis. So what are some observed things that we see banks that have good meetings? First of all, they got board members who are educated and informed. They're prepared for meetings. They come in and they've already read it. They're not reading it during the meeting. The agendas are structured and they've got a strong moderator. There's nothing better than a strong moderator who can cut off irrelevant conversation when it needs to be cut off. And then lastly, it's well thought out and presented analytics. If you're going to get a 50-page report, there needs to be a one to 1.5 page summary up front that can be used for most of the discussion points. And then let me just tell you some conclusions I look at this, and I think the bank director role is very, very well defined. More defined than any other director position in any other industry. The regulators in our industry have gone so far as to spell out what we can do in terms of insider loans and how we can go about doing it. No other industry has that. We're the only industry that has rego loans. The board education and training, though, because of the litigation that's going on, because we're such a litigious society, is more mission critical than it's ever been. Make sure you are documenting all the training that you're getting. One thing I didn't cover, but I'll just put it in. Our firm is just a huge believer. If you're going to get trained with your own data. As much as you possibly can, get trained with your own data. I think you can have effective board meetings, but it's going to take change. It's going to take, a chairperson who's actually going to have a gavel and use it. Not many board members have gavels, and very rarely do I see it used. I think people have to all have a common goal, whatever that is. Mostly it's building value, but it might be something else. It needs to be understood and communicated throughout the organization. And then the board's got to be an active role in making sure that all policies and strategic plans and action items and the people that we hire are geared towards getting us towards that goal, towards that vision. And recognize that you need a corporate governance system. Corporate governance doesn't just happen. It's something that takes a considerable amount of time and a considerable amount of effort to follow through. I am not going to go through this because I understand, Steve, you're going to mail this out, but we have a checklist that we put together. I am not going to go through it today, but it's 2 pages long. These are the things that you need to do to make sure that you've got an effective corporate governance system. Steve, I think I have time for 1 or 2 questions, and then we'll let people get on their way.
Don, we have a question on compensation, more along the lines of how do you recommend the board interacting with management and setting compensation? What is that process, and how to overcome any kind of awkwardness that may happen?
Well, you set a budget early on, and the budget will talk to what the total salaries are going to look like. I don't think board members need to know the detail of who makes what, but they do need to know what the total comp picture looks like. And the board needs to say, these are the kind of raises we're going to give, and these are the kind of incentive plans we're going to give, or stock plans, or whatever it might be. At the end of the term, be it 6 months or a year, whenever the board decides it's going to do payouts, the board needs to look at the quantitative data, make sure that the goals have been met, that there's no gamesmanship going on, and then they should approve the budget pool, if you will, to be allocated by the senior officer or senior officers. The only salaries that I ever see boards getting involved in, or should be getting involved in, are C-suite level, and it's always going to be for the CEO. It may also be for some other people, particularly if you've got like an office of the president kind of a thing going. But this is an area where I think boards get way too much detail. They don't need to know that Teller, A, went from making $30,000 to $33,000. They just don't need to know that. They need to know comp is going to move this much, and here's what we're going to do to manage it.
We have a question on rotations of boards and board members and committees. This one's specific to the loan committee. Are there vulnerabilities in not rotating board members on the board loan committee, and then maybe extrapolate that to all committees, Don?
Yeah, I have a bias on the loan committee, and that I don't think board members should be on the loan committee. So I'll start with that one, and then any exceptions should be going to the full board, not to a committee. Committees take risk for the decisions that they're entrusted to make. So in loan committee, if you get 4 loan board members on loan committee, and you have 5 that aren't, you've got a 9-person board. Those 4 members on the loan committee are taking a lot more risk than the other 5. There's just no doubt about it. So my personal opinion is that boards shouldn't be involved in loan committees. But I'll answer the broader question. I do think where possible, it's good maybe every 3 years or so to have some kind of a rotation, because I think that's the only way that boards can be fully versed in everything that's going on in the bank. But what you can do immediately to overcome that issue is we have a standing rule that every single board member is invited to every single committee meeting if they want to come. They're not voting members, but they're welcome to sit through the meeting and listen and watch what's going on. There's absolutely no reason that you can't have the full board invited to sit through some committee meetings. Now, sometimes board members take advantage of that, and sometimes they don't. We recently, at the board that I sit on, we recently, set we had a compensation discussion that really was talking about how much we were going to change comp, and it was so big that we opened it up and asked the whole board to come to a special 3-hour session on it, and we had 100% attendance at it. And we spelled out in the minutes that we thought it was that big of an issue that we brought the whole board in. The regulators loved it. They got back to us and said, that's exactly the kind of corporate governance we're looking for, that you guys are identifying, through your enterprise risk process, you're identifying the key risks that you face. Each one of those key risks you need to be mitigating. Part of that mitigation is board education and training and discussion. Make sure that for every key risk, you've got something in your board minutes showing that you're addressing it, and you'll be fine.
I think we have time for one more, Don, if you don't mind.
One more.
Okay. This has to do with succession planning, and I think it dovetails when we're talking about the awkwardness of compensation. How far down should succession planning happen at the board mandated relative to management? And then how much of that should be communicated to management in order to keep them happy and motivated, but also informed?
Two-part question. First part is the board itself is responsible for board succession and senior management succession. It has a responsibility to make sure that succession is happening at other levels, but it's not responsible for administering that program. The senior officers are to administer that program. So I, as a board member, want to know if President A is no longer there, or if CFO B is no longer there, what do we do? But if a financial analyst were to depart, I want to just know that the CFO has a plan there, and that they're not caught unawares. So I think the easy answer on that is you go down one level, one level in the organization, but then you need to make sure that you're fostering an environment where everybody has a succession plan throughout the entire organization. The communication to the employees is a cultural thing. In our organization in particular, at FinPro, we communicate very clearly to everybody what their succession path, what their future promotional path looks like. We also tell them that if they want to be promoted, they've got to have a backfill, i.e. they have to have a succession plan for somebody who can step in and do their job. It's a two-part test. And again, that's fostering that we are one big family. If something happens to you, you need to make sure that your job can be done by somebody. And likewise, we want to make sure that you can do the job of the person above you, and that we give you an opportunity to be promoted and grow in the organization. I would love to see that be kind of the norm across the industry, but I don't think it is today. And I think we're not going to be able to get there as quick as we'd like, because changing culture is a very difficult thing to do, and changing culture really requires movement at the very top of the house, and it's got to be demonstrable movement, and it's got to be consistent, and that means it takes time. Thank you, Steve, and thank you, everybody in the audience, for giving me the time. I hope this worked out okay with me being in California. It was kind of unavoidable. Steve, I'm going to turn the webinar back over to you at this point.
Great, thanks, Don. Don mentioned 2 webinars coming up relative to what we've kind of referred to as the Trump bump. We're monitoring the economic situation. We had our first emergency meeting in mid-December when the 10-year popped a good 30 to 40 basis points over the span of a period of 24 hours almost. Our final 2 out of the set of 4 for now scheduled will occur on February 16th and March 16th. If you do not have access or have not registered, these are available to all and only FinPro clients or webinar package subscribers. So it is available to all but only FinPro clients or webinar package subscribers. You cannot buy access to these a la carte. Also want to note on March 10th, we have our Directors and Officers Conference. This is being run in conjunction. The administrative items are being handled by NJ Bankers. Please do not be confused by that. All of FinPro's clients, regardless of where you reside, are invited. March 10th, the Directors and Officers Conference. Don will be doing an industry update on strategy. We'll have a legal update. We also have an interesting fintech panel. We are going to finally settle the debate between what the core providers are doing for you. We have a representative from COCC, which we find to be one of the more amenable and nimble core providers. We're going to have that panel. Also on that panel is the president of the Golden Contract Coalition, which is which is a coalition of bankers that they're signing together to create critical mass to negotiate against unfair terms relative to the oligopoly that the core providers have. That will be chaired by Steve Musso from FinPro. We also have a representative from the College State Bank supervisors. The topic escapes me for now. That is on March 10th. We have the checklist. We started doing these this year. We got great feedback relative to the checklist. Don said we'll be sending that out. Please keep in mind that is available only to attendees. So if you have the package going forward, there is an incentive, but the checklist really only makes sense to those who attend it because it is just that. It's a checklist. It's not an all-encompassing list and a download of knowledge items. So that checklist will be sent to attendees only. Again, the webinar package is available if you're not subscribed yet to the webinar package, and we look forward to seeing all of you on the next webinar, February 2nd, stress testing. Thank you.